Hello, everybody. Thanks for attending today's cybersecurity webinar, Countdown to CPRA. This is the latest in our latest installment in our cybersecurity webinar series, and the last we'll have for 2022, as far as I know. Before we begin, we have a few housekeeping items. If you have any questions during the webinar, you can submit them through the Q&A widget at the bottom of your screen. We'll try and answer these during the webcast if we can, but if we need a fuller answer or run out of time, we'll answer them later on by email. A copy of today's slide deck is available in the resource widget, and you can find additional answers to some common technical issues in the help widget at the bottom of the screen. The webinar today is CLE approved in California, Illinois, and Texas for 1 hour of general credit, in Missouri for 1.2 hours of general credit, and in New York for 1 hour of skills credit for experienced and transitional attorneys. We award CLE based on attendance for the full 60 minutes. We'll display and announce secret words in 2 polls during the webinar. You'll be required to select the secret word that I give out verbally from the multiple choice list on the screen. So please respond to the 2 polls quickly to demonstrate your continued engagement and earn the full CLE credit. We value your opinions and appreciate your participation in today's course. So with that, thank you again for attending today. We're going to talk about some of the soon-to-be effective requirements of the California Privacy Rights Act. And so we have today an excellent panel. Some of our regulars here in the cybersecurity practice at Thompson Coburn. I'm Jim Shreve. I chair the cybersecurity practice here, and I've been doing privacy and cybersecurity for a long time, including dealing with a lot of these state law issues, of which California has been at the forefront quite often. And so I'll hand it off to my colleague, Luke Sosnicki.
Hi, everybody. Thank you, Jim. My name is Luke Sosnicki. I am a partner in Thompson Coburn's Los Angeles office. I'm a litigator. I have spent the majority of my career defending clients, including a large number of financial institutions in various types of consumer claims, UDAP claims, and in the last few years, that includes claims relating to data privacy and security issues. Libby?
Thanks, Luke. Hi, good afternoon. My name is Libby Casale, and I'm an associate in the business litigation practice group, and I am in the St. Louis office of Thompson Coburn. And now I'll turn it back to Jim.
Thanks, everybody. So today we're going to go over some of the requirements of the California Privacy Rights Act, which you mentioned is going to be effective on January 1st. Many of you may be well down the road in preparing for CPRA and these new requirements. Some may be less far down that road. Some may be saying, what is the CPRA of which you speak? So there's something here in the webinar for everybody. Our primary goals for you here today are to help you identify areas of CPRA that are most likely to result in companies getting in trouble. And if you're still working on preparation for it, to note some of the areas maybe to prioritize in that compliance process. And so even if you can't do quite everything before January 1st, identifying what are the most important things to handle up front, because it may be in the most trouble. So these are the areas we're going to go through. We have questions at the end. If you do have questions during the webinar, we can try and address those during it as well. So I mentioned California has always been a leader in privacy. And I would note also California has a somewhat unique legal mechanism in the law that makes it much easier than in most states to enact laws through a ballot initiative. And the original privacy law here is CCPA, the California Consumer Privacy Act, was enacted in 2018 by the legislature with the idea of heading off a ballot initiative. CPRA, which we're talking about here today, is the results of a subsequent 2020 ballot initiative that did get on the ballot, was voted on, to strengthen the requirements of CCPA, to clarify some points, and to importantly, to extend certain exemptions in CCPA, primarily around business-to-business transactions and employment privacy. Most of the requirements of CPRA can be enforced from January 1st, 2023. One of the things CPRA did was establish the California Privacy Protection Agency, and then in charge that agency with drafting rules to augment and clarify the statutory requirements in CPRA. That process is not yet complete. I mean, the CPPA has stood up, but they haven't issued those final rules as everybody expected they probably would before January 1st. And they're not going to do that. So, and I would also note, incidentally, that the person, I mentioned the ballot initiatives, the person who was the primary driver behind those ballot initiatives was named to the CPPA board this last year. I would also note that members of Congress from California have been the primary blockage on, lately at least, on getting federal privacy legislation. And they've stopped that effort out of concerns that federal law would weaken the privacy standards that have been set up by CCPA and CPRA. So clearly privacy in California is a big deal. Luke?
I certainly agree that it's a big deal. Just to add to what Jim said, I guess a couple things unique to the CPRA. As Jim noted, it's an amendment of existing law. It is not a brand new statute. It was brought about as a ballot initiative, but as a ballot initiative, the application is still amendment of the CCPA, which is existing law. And as a result, what we're going to focus on today when talking about the key points for compliance are really the differences between the CCPA and the CPRA. So we're going to look at what the existing CCPA requires businesses to do to comply and how the CPRA changes that in important ways. And the other thing that Jim mentioned, the other kind of sea change is the CPPA itself. And at the end of this presentation, we'll talk about two things. The ongoing rulemaking, which, as Jim noted, has not been completed. It was supposed to have been completed before the statute took effect. That didn't happen. The rulemaking is ongoing. And then we'll give you some thoughts on, in light of the ongoing rulemaking, what do we see in terms of, what do we expect in terms of enforcement, and in terms of what issues the CPPA might try to look at first. So, Jim?
Well, thanks. So let's start with the comparison. CPRA makes some important changes to definitions. Libby, could you talk to us about some of those?
Sure. So one of the key changes from CCPA to CPRA is the definition of a business. So the CCPA currently applies to for-profit businesses that do business in California, collect consumers' personal information, or have others collect personal information for them, determine why and how that information is processed, and meet any of the following thresholds. So that's have a gross annual revenue of over $25 million, buy, receive, or sell the personal information of 50,000 or more California resident household or devices, or derives 50% or more of its annual revenue from selling California residents' personal information. So the thresholds that will change on January 1st, 2023, when CPRA takes effect. So starting in 2023, to meet the second threshold, businesses must annually buy, sell, or share the personal information of 100,000 or more California consumers or households. And it also drops the references to devices that was in CCPA. In addition, the last threshold will include businesses that derive 50% or more of their annual revenue from selling or sharing consumers' personal information. And CPRA also provides that a business includes any entity that controls or is controlled by a business that shares common branding with the business and with whom the business shares consumers' personal information. And a joint venture or partnership where each business has at least 40% interest is now considered a business under the CPRA. And Jim, I'll turn it back to you.
Oh, thanks, Libby. I mentioned before about exemptions. So CCPA had exemptions to its requirements for personal information that was obtained in business-to-business relationships and in employment relationships. Originally, these were scheduled to expire at the end of 2020, but they were extended for 2 years with the passage of CPRA. In this last term, the legislature considered bills that would have further extended the exemptions either for a couple of years or permanently. Those bills were not acted upon. It didn't seem that either really got that close to being passed. So those exemptions are going to expire at the end of this year. And so the first one is for employee information. And I would note that employee information is defined broadly. So it not only looks at those who are your actual employees, but those who are applying for jobs, your directors, officers, owners, independent contractors. So it's pretty broad. And so you need to think about that. So when you're looking at this, I think you need to, there can be a significant issue here because when that exemption expires and employees are included, the data practices around a company's employees are often very different than for their customers. There's a lot of companies that need to collect a significant amount of information about their employees for legal compliance purposes, to administer benefits, for a variety of reasons. So you may have a lot more personal information on your employees than you might have on your customers. And then how you share that information, how you use that information may be quite different than for your customers. And so I've certainly already seen that a lot of companies are determining that they might have a privacy policy, but to amend that to cover employees would be significant, make it very difficult and confusing for everyone. And so they've decided to have a second privacy policy that's purely for employees. And so that raises some questions. Business to business, I mean, since many privacy requirements in the US are consumer only, this may be a new experience for a lot of businesses. So a lot of companies may not have a privacy policy, have never been subject to a requirement to have one and didn't voluntarily put one out if they didn't need to. So now companies are determining they need to have one. They need to draft one. I would say if this is the case, please don't copy one from another company and post it up as your own. Don't just use an online template that you might find, because there are a lot of them out there and they can be useful, but don't just put your name in it and post it up on your website. The privacy policy needs to be tailored to your actual practices. And so if you are in business to business space and now you have to do this, you put some thought into it and don't put something up that may not be entirely correct. Sensitive personal information. Libby?
Jim, if I can just jump in very quickly on the prior slide, just a kind of a practice point, or kind of what we've seen. The combination of the sunsetting of the employee exemption and the B2B exemption has really, I don't want to use the word ensnared, but has led to a lot of our clients and a lot of inquiries regarding whether the entity is covered by the CCPA and now the CPRA in the first place. So we've had quite a few actually, inquiries come in where a company is engaged primarily or exclusively in business-to-business transactions, but has one or even a few or even one California employees. And under the existing CCPA, if those entities didn't collect information from California consumers other than as representatives of businesses, even if they otherwise met the criteria for being covered under the CCPA, they didn't have to treat the information as CCPA covered. And what we're finding is a lot of folks are finding themselves in the boat of, well, we have, again, one or two California employees who who represent us in California with respect to business sales. And the punchline is, if you meet the revenue threshold, if your company meets the revenue threshold, we just got a question of whether it includes revenue just in California or nationwide. It's revenue anywhere. It's not California specific revenue. So if you meet the revenue threshold and you have one California employee, you're now subject to the CCPA on a larger scale. And I think that has come as a surprise to certainly a number of our clients. And as a practice pointer, you really need, the sunsetting of these two exemptions really require you to reevaluate whether you're subject in the first place. So even if you, under the CCPA, you got advice and received an opinion that you're not covered, you really need to take a look at these two exemptions, because now you might be. Sorry, Jim?
No, thanks, Luke. That's really, really good information. Libby, do you want to tell us more about sensitive personal information?
Sure. Thanks, Jim. So another change from CCPA to CPRA is the addition of the new category of sensitive personal information. And as set out on this slide, it includes things like Social Security numbers, passport number, genetic information, and precise geolocation data. So beginning in 2023, consumers will have an additional right to limit a business's use and disclosure of this subset of personal information. So under the CPRA, consumers now have the right to restrict the use to only what is necessary to perform services or provide goods requested by the consumer. And a business that collects sensitive information must provide a link on its homepage restricting its use or disclosure. And personal information and sensitive personal information do not include publicly available information, and that's information that's lawfully made available from government records. And in 2023, the definition of publicly available information will also include information that a business has a reasonable basis to believe is lawfully made available to the general public by the consumer, or widely distributed media, or certain information disclosed by a consumer and made available if the consumer has not restricted the information to a specific audience. So I'll turn it back to you, Jim. Thanks.
Thanks. And so with that, we have our first question for CLE requirements. So today's secret word is consumer. So from the list on the screen, please select the word consumer, and then we will record your response and move on. And you have to respond to show that you're listening in for CLE purposes. So please choose consumer among the items on the screen. Okay. Okay, I'll give it just a few seconds here. Choose consumer, and then we're going to move on. Last few people choose consumer. All right, we're going to move on. Okay, so CPRA differs from CCPA in that it introduces a few new consumer rights, a few new requirements on businesses subject to the law. It introduces this idea of the right to correct. And so the consumer can then request that you correct personal information that they believe is incorrect, the business has. in some ways, this can be good for a business. I mean, you want to have up-to-date information about people, whether it's contact information or other things like that. And so that can be a good thing. The problem can come in where the information or the dispute about the information is not so objective or clear-cut. What about if a consumer wants to correct something that they perceive to be bad about them, but that the company believes is accurate? And so there's a little bit of guidance in the statute. It requires commercially reasonable efforts to correct the information. It's good to verify your information or know the source from which you got the information in the first place. That's going to help with this process considerably. It's going to be good to have a process to fairly determine how these correction requests are addressed and amend based on your experiences. I think, and then so as the requests come in, change your process to address problems, and then stick to that process. Have something and stick to it. I think I would note that the requirements around this process is one of many points that are due to be addressed in the CPPA rules to come out. But even before then, it's good to think about how you're going to at least identify and escalate these requests internally. There's also a right to opt out of certain sharing of personal information. And so it's in the context of sharing with third parties for cross-content behavioral advertising. This is a hot and complex topic, and again, the rules are going to shed more light on it. And I would also note that the sharing doesn't need to be for compensation or other consideration, which is a little different than what we had for the previously existing requirements around sales of personal information. And so we have new limits, potential limits on the use and disclosure of sensitive personal information, as Libby alluded to, that the statute says you can direct a business to share and use sensitive personal information only as necessary to perform the services or provide the goods reasonably expected by an average consumer who requests such goods or services. Obviously, as soon as you introduce something like the average consumer, it becomes a much more difficult determination and much more subjective necessarily. You have to include on your website a link that titled, limit the use of my sensitive personal information. I would note this can be of particular importance for employees, because as I noted, companies tend to need to have more sensitive personal information about their employees than they might need to have about their customers. Here, there is value in having some kind of retention and use schedule for information, because then you don't have data sitting around that you don't need. But it also helps in responding to requests if you might need that information, either to use it or share it for particular legal or compliance purposes. It gives you something to easily and quickly point to as to why you can't possibly comply with all of the consumer's requests. There's also, I've noted, an opt-out right for certain automated decision-making under CPRA. There are new disclosure requirements, certain new requirements for both a privacy policy content and around giving notice prior to the collection of personal information. And that includes information about California privacy rights, more granular descriptions about personal information collection, sharing, and use, and around how long personal information is retained, how it's destroyed, and information about third-party collection of personal information. There are new requirements relating to the honoring of consumer requests, particularly around web browsers. If you look at the comments to the draft rules that have been put out to this point by CPPA, a lot of points along those lines as to how to honor those requests. There's also requirements in there about data minimization and use limitations. And here's an area where if you're familiar with the EU's GDPR, this is going to seem familiar. You can see the influences of GDPR in these kind of requirements. Historically in the US, there have not been limits on what personal information you can collect outside of certain sensitive personal information, or like on protected classes, or certain information like Social Security numbers where it's more sensitive, or how you use information once you've properly collected it. CCPA, CPRA are introducing EU-style limitations, even if in a lighter context than what they have there. So, Luke.
Thank you. So this is going to be the last of our slides or discussion, the last part of our discussion about how the CCPA and CPRA differ before we really move on to the nuts and bolts of, well, what do you need to do to comply? So what we're talking about here is what the statute changed, why that's important, and we can use that as background and context, again, for what do you actually need to do as a practical matter in order to comply with the CPRA's changes to the CCPA. And this last one is a big one that, again, sets up something that entities are going to certainly need to do. And what that is the CPRA imposes new contractual requirements on data sharing and data selling. And really, to understand how the CPRA differs from the CCPA, you need to understand how the CCPA set up regulations limiting data sharing and selling in the first place. And that is, in short, if you sell data, you need to give consumers a right to opt out of those sales. The caveat to that for businesses is that under the CCPA, so under the former statute, still operative, soon to be former statute, providing data to a service provider subject to contractual limitations on what they can do with that data wasn't a sale. Because it wasn't a sale, it wasn't subject to the opt-out rights. So the important distinction or the important purpose of imposing contractual limitations on selling, on sharing data, not selling, on sharing data with other parties was to ensure that you can share personal information with service providers necessary to perform your business function without giving, under the law, the required opt-out right. And the sea change for the CPRA's treatment of data sharing is that contractual arrangements are now going to be required starting January 1st for any type of data sharing or selling. And what types of contractual provisions your particular data selling or sharing is going to require depends on the type of entity with which you intend to share. And on that point, we finally come to the slide, which is the CPRA has sets three types of parties with whom you can potentially, or businesses will share personal information that they've collected. They are a contractor, which is an entity that receives personal information from a business for a business purpose. A service provider, which is an entity that receives personal information from or on behalf of. So if an entity collects information on behalf of a business, it's more likely than not a service provider. And that carries out processing activities of that information also for a business purpose. And the third party is really defined by what the other two categories are not. It's something other than a service provider or a contractor that also receives personal information from a business. And the distinctions, which are highly technical, and we're not going to go through every variance in these definitions and what the specific language requires, or the specific contractual language requires, but we're going to cover the key ones. But these distinctions are important because, again, the category, the type of entity with which you intend to share governs the contract that you now need to enter into, which again applies to all types of sharing, which is a change from the CCPA. So what do So what does the CPRA require with respect to these contractual agreements? So the terms that are required for all such agreements are listed on the slide. I'll just go through them quickly. Must specify the personal information is sold or disclosed for a limited and specified purpose. So you need to explain in the contract itself why you're selling it. Must obligate the third-party service provider or contractor to comply with the CPRA. This is a very important concept, and it's the concept of pass-through obligations. The CPRA is much heavier on pass-through obligations imposed on the parties that receive the personal information than the CCPA was. So if you are a recipient of personal information from a business, the contract must now require you to provide the same level of protections, of privacy protections, under the CCPRA and comply with the CPRA more generally. Number 3, must grant the business rights to take steps to ensure that the recipient uses the personal information transferred in a manner consistent with the business's obligations. This is a second important concept that the CPRA is much heavier on than the CCPA, which is the duty of monitoring. The CPRA imposes specific obligations on businesses that disclose or sell personal information to make sure that after that information is transferred, the transferee is treating it in compliance with the CCPA. So it's not just a pass-through obligation on behalf of the recipient of the data, but it's also an obligation that remains with the business that collected the data to on some level keep track and ensure that the information is still being protected. And those are really 3, 4, and 5. So number 4 is must require the recipient to notify the business if it can no longer meet its obligations under the CPRA, and must grant the business the right upon notice to take reasonable appropriate steps to remediate unauthorized use. So this applies now to any contract that governs the sharing or selling of CPRA covered data that the business collects. If you share data with a contractor or a service provider, subject to contractual limitations that you do not intend to make subject to an opt-out right, then there are additional requirements that such a contract is going to require, and requires a business purpose. Number 1, so the contract needs to state the business purpose for the sharing. Number 2, very important, the contract itself must prohibit the recipient from selling or sharing the personal information, so from transferring it further, from selling or sharing it further, from retaining, using, or disclosing it for any other purpose than the business purpose specified, or retaining, using, or disclosing it outside of the relationship. So the bottom line is, if you intend to transfer information to a service provider or a contractor, so an entity that is performing services for you, and it's necessary for your business, and you don't intend to make it subject to an opt-out right, although it still might be subject to limitations, you need to ensure that your contract includes these specific provisions, including provisions in number 2. Number 3, must prohibit the service provider or contractor from combining the personal information that it receives from you with personal information it receives from other sources. Should allow the business to monitor the receiving party's compliance. And number 5 is another really, really important point along the theme of pass-through obligations. If your service provider or your contractor intends to use a sub-processor or a subcontractor to further process that data, your contract with that entity needs to make sure that the business or the contractor or the service provider notifies you if it is going to do that. And if it is going to do that, also imposes its own CPRA compliant contracts on the subcontractors that it chooses. So this is, again, under the general theme of pass-through obligations. So we'll get to this in more detail in a minute, but you can start to see where CPRA compliance is going to the extent that you haven't yet started, is going to require some work. The bottom line being, if you have existing service provider contractor agreements, you need to take a look at those to make sure that you're now using the specific language that the CPRA requires with respect to the data you're sharing. If you're selling personal information, if you're in the business of selling personal information, if you're a data broker and you have arrangements by which you were selling personal information to third parties that were not covered by a contract, you need to take a look at those relationships and figure out whether under the CPRA a contractual agreement is going to be required.
All right. Thanks, Luke. Thanks, Luke. And I want to give a response to, at least in part, to a few questions that have come in, largely around nonprofits and CCPA and CPRA. I would note that both CCPA, CPRA exclude nonprofits from the definition of business. So, these primary requirements under CCPA aren't going to apply if you're a nonprofit entity, at least not as a business. The definition in CCPA for service provider used to include that you had to be for profit, but that was removed by CPRA. And then we have these new definitions that Luke's talking about, contractor and third party, that don't explicitly mention for profit or not. So I think in general, if you're a not-for-profit, you're probably not going to be under the business requirements, but you certainly could be under for some of the other requirements. And I note that these relationships can get very complex. And so what if you have a not-for-profit that's engaged in certain for-profit activities? That can get complex. That's something we probably should talk through, because it's more complex than I can give a quick answer to right here. So with that, let's move into the next part. So we talked about some of the changes, some of the new requirements. How do you comply with them? Or at least comply with them as many as possible before January 1st. And I would urge you, have a plan for your compliance. Map out what are the things you need to do and how you intend to do it. Obviously, it not only helps you to make sure you're complying with all of the various requirements that you're subject to, but it also shows if there is a complaint, if the California AG comes calling to you, it gives you something to show. Whereas even if you can say, yeah, we don't have something that does all the requirements yet, but we're trying, we have a plan to do that, and here's when we anticipate having all that in place. That's very likely going to help. It doesn't necessarily mean that's going to get you off the hook, but it certainly gives you a better story to tell. And I'd say January 1st obviously is coming very soon. We don't have the regulations yet, and we don't know exactly when we will. So I think it makes sense to look at the CPRA requirements and think about how you would meet them, even if only in a general sort of way. Identify what is going to be harder to do, what's going to take more time and thought, and what you might be able to do fairly easily. And also consider processes that you may already have in place that can be adopted for CPRA compliance or adapted to use for CPRA purposes. Like as part of identifying and escalating consumer privacy requests that come in from consumers or employees, you may be able to use existing interaction processes to do that, or at least learn from what has worked in some other contexts along those same lines. So about business, Libby, do you want to have some thoughts on that?
Sure. So one thing to consider is whether or not your company is still covered with the changes in the definition of a business from CCPA to CPRA. And on the flip side, are you now fitting within the definition of business where you may not have before? So one thing to think about is the increase in threshold from 50,000 to 100,000 consumers. So these are really kind of things to consider and really look at the definition of a business and see, does the change impact your organization? And I'll turn it back to Jim.
Oh, thanks. So, talking about the sharing, think about what you do and that could fit under the definitions of sale or sharing of personal information. Urge you to cast a wide net for things and then narrow it down. Consider things like cooperative arrangements, where you may be sharing, or there's certainly compliance-related sites that, let's say, for any money laundering compliance or fraud mitigation, where you may share information on a cooperative basis. Those kind of things require some thought as to whether that could be covered under these. And if personal information must be shared in a way that could be considered a sale, document why that kind of sharing is necessary. I'd also urge you to be forward-thinking about this. Consider plans that may be in development for how you may share and use information. It is much easier to build those privacy requirements into a developing program than to do it later on when the program is already up and running. And so with that, we have our second of two secret words. The second secret word is confirm. So please choose confirm from the list on the screen, and we will move on to the last part of the webinar. So please choose confirm on your screen, and give you a few seconds to go ahead and do that. Okay, just a few more seconds, and then we're going to move on. Last chance. Go ahead and submit it for your CLEs. All right, we're going to move on. So having a process to verify and comply with consumer requests. So we talked about the right to correct, right to opt out of sharing, and limiting use of certain information. Many companies out there are going to use an established customer relationship process to intake these kind of privacy requests under CPRA. Doing that is going to be important to use internal policies and procedures and training of relationship staff so that you can identify when these kind of requests come in with many others, so that they get routed the right way, they get escalated to the right people. First of all, not all consumers or employees may have these rights. Then there's a required verification process that has to go on. It may take you a while to figure out, what is all the information we have relating to this person, and where is it, how is it used, and then to act on the request, whether it's limiting sharing or deleting that information. And there are fairly short timeframes for compliance. In order to meet those, it's going to be crucial to identify those and get them to the right people very fast, so that you're not spending a lot of time there. And so again, I think having a documented process in place for this helps both as part of that compliance, and it helps to show that you're trying to comply if there is some complaint to the CPPA or the AG's office. Also note about data minimization. And this is a big trend in privacy. Companies, particularly in the marketing part of companies, used to collect as much information as possible and then figure out how to use it later. Now that data sometimes has become a liability. For retention of personal information, for new collection, think about what you really need to perform the tasks for which that personal information was collected. You also may need to limit the ways in which the collected data is shared and used internally. So you may need some kind of process to tag the data, make sure it's only going to the right people, it's only being used for the right processes, so as to comply with the CPRA requirements. So with that, let's talk about notices. Luke.
All right, so now we're really getting into the nuts and bolts of the CPRA is coming, so what do you need to do? So as Jim just said, definitely review your processes. At a baseline level, you need to make sure, as Jim noted, that your P&Ps reflect the new rights that consumers have, that you inform your employees of these new rights and inform them how to deal with them. I think that's going to be a really easy enforcement point if you are CPRA covered and a request were to come in for correction, for example, and the P&Ps didn't address correction and it was rejected outright. So I think really important to look at P&Ps, make sure they're keeping up, quote unquote, with the times. The next kind of easy point, and when I say easy, I don't mean to imply it's easy, but at least a high level point, is take a look at your notices, your CCPA notices, and your CCPA compliant privacy policy, because the CPRA is going to imposes new obligations with respect to both. So just backing up a little bit, because we understand that this is a comparison presentation, the CPRA requires specific notices to consumers. The existing law requires specific notices to go to consumers, informing them of certain information about what information is collected, what the company does with it, and then in some circumstances, for what purpose the information is being collected and used. And the CPRA requires specific revisions to those notices, the big one being the notice of collection. So the notice of collection, so this is the notice that you give to California consumers at or before the point of collection, and which now includes, really importantly, employees, must, among other things, disclose the collected sensitive personal information so that consumers may decide whether they want to exercise the new right of limitation of use of sensitive personal information. Must now address the new right of opt-out of sharing, which, as we've noted, is the concept of disclosing personal information for behavioral advertising, cross-content behavioral advertising, and must now disclose the company's retention policy, which falls under the themes that Jim was just talking about of data minimization and data limitation. These are concrete things that the CPRA now requires must be added to an existing notice of collection that was previously compliant with the CPRA. So again, as a compliance point, again, I don't mean to say easy, but as a compliance point, easy starting point anyway, to look at your notice of collection and see how it needs to be updated. Same thing with respect to the privacy policy. The CPRA, the CCPA, the existing statute, requires a privacy policy to be posted that informs consumers of many of the same things that a notice of collection requires to be disclosed. Also requires the privacy policy to explain what rights consumers have under California law, including under the CCPA. The CPRA, as we've discussed throughout, imposes new consumer rights and new business obligations. A second quote unquote easy or at least high level compliance point is take a look at your privacy policy, make sure the language of your privacy policy matches the requirements of the new CPRA, especially with respect to the new consumer rights that the CPRA grants, which is a right of correction, right of limitation, and certainly right to opt out of sharing. And to Jim's earlier point, I will say if your CCPA compliance at any level involve borrowing or using a template privacy policy and tailoring it, if not, albeit not significantly for your business, now is the time to take a look at it and make sure that it accurately describes what information you're collecting and what you're doing with it. Which is a long way of saying, if you didn't do it in full the first time, now is really the time to do it for two reasons. Number one, because the regulators, I think, are at least potentially might look at it as a second chance. And the second reason is now that there is going to be a dedicated agency to enforce the statute starting next year. Again, if you didn't do it 100% the first time, do it 100% right the second. And following up on what I talked about earlier, review and update third-party agreements. Another high-level compliance point, you need to review your, we'll start with the relationship. So you start with the relationship with your vendors. You need to figure out whether that vendor is a service provider or whether it's a contractor under that definition. And once you've done that, you need to look at the agreement and make sure that it contains the language that the CPRA requires in terms of data limitation for that particular entity. And on a similar vein, if you're disclosing, if you're selling personal information or sharing personal information with someone other than a contractor or service provider, you need to take the time to figure out whether a contract is required there. So really, again, nuts and bolts of high-level things that you can address, or at least start seriously thinking about offhand to be a CPRA compliant.
Okay.
Jim?
No, thanks, Luke. So when CCPA was enacted, it was the only law of its kind out there among the states. There were certainly a lot of entities, a lot of clients that thought, okay, well, we're going to comply with that. We're going to limit it to just California. But then, since then, we have 4 states, at least, that have enacted laws that are along the same lines as CCPA. So Virginia was the first, then Colorado, Utah, Connecticut. And so then it raises the question of what do we do to comply with all of these, and how do we set up a program that we don't have to amend every time there's a new law? And so a lot of companies are facing this important strategic question, which is, do we treat everybody the same and essentially apply some of these laws that may only apply in a given state more broadly, even though we're giving more rights out? Or do we want to continue to do it state by state and apply them only where consumers or employees live? And there's no right answer there. I mean, I think that in the one case, you're giving rights more broadly than you have to, but it creates a bigger administrative burden for doing that. And that affects both the drafting of your privacy policies and other external privacy policy statements, and kind of behind the scenes, what you're doing to comply with those. Among these other states, I would in general see the California requirements are still the most stringent overall. In certain areas, of these other 4 laws, the one I would urge you to most watch is the one in Colorado, which has requirements that are in some ways closest to what CCPA has done, but also diverges a little bit from it and gives a fair amount of latitude to the Colorado AG's office in drafting regulations under that law to potentially expand some of the requirements of it, and that they have done so. And that Colorado law, in some ways, seems to be a more palatable model to use for some states than California might be. So that's one just to definitely watch going forward. And if you want to look for one that goes beyond CCPA, I think that's the one of these that's going to do that to this point. So, moving on, the rulemaking process, which isn't complete yet, as we've said. We're going to have an effective CPRA without the rules from the Privacy Protection Agency. In July, they issued draft rules. November, there were a whole modified set, significant changes to them. The comment period to those ended just a few weeks ago. There were, at least by my count, 155 comments on the CPPA's website to the revised rules. What's going to happen next? It's hard to say. I mean, there were so many comments and so many revisions. Normally in a rulemaking process, you might issue a proposed rule, revise it, and then it goes to final. I almost wonder here, because there's so many holes still, so many issues still outstanding, we might have another draft set before it goes final, since they've missed the January 1st deadline anyway. But we don't know. I mean, I think I would still steam ahead to the extent possible for compliance, but be aware that it's possible the rules may still take a while to come out. Luke, any thoughts about enforcement?
Yeah, so the slated date for enforcement to begin, for the CPPA's enforcement to begin, is actually mid next year. It's July 2023. But in the last round of regulations, the CPPA did give some indication that it would at least consider the fact that there aren't final regulations in whatever enforcement actions it chooses to bring. So I think that there is at least some hint of recognition by the regulators that it's tough to comply with a statute that through no fault of the public hasn't been finalized yet. How that's going to play out in practice, I guess we're going to have to see. I think I agree, Jim, that it's likely we're going to have another round of these. It's even possible that I'll say possible, but not likely that the enforcement date itself would actually be moved. And in terms of what we can expect from enforcement, I think the only firm we've received certainly some public comments about the types of activities that the CPPA might focus on. But really, the most concrete example we have is a stipulated judgment that was publicized that the Attorney General's office reached with CPRA earlier this year. And what that focused on was a couple things. It focused on an alleged failure to disclose that information was being sold. And I guess the ancillary failure to honor opt-out requests with respect to the sale of personal information. And a really interesting and important topic, that settlement also addressed a failure to recognize automatic global privacy control signals as an opt-out. So in terms of CPPA's primary focuses of compliance, again, it's difficult to say, but it seems that the low-hanging fruit might come first, which is, again, some of the things that we've been discussing for the entire presentation. The low-hanging fruit would be selling personal information without disclosing it to consumers and without providing an opt-out right, which is curable by simply amending your privacy policy, by reviewing your processes and amending your privacy policy to comply. I think the global privacy controls is a little bit more difficult. But again, in terms of bang for your buck on compliance and risk mitigation, stick to the basics. Make sure you're accurately disclosing what you're collecting, and what you're doing with it in your notices. Make sure you're honoring consumer requests, and I think in the limited time that everyone has, I think, to comply with the CPRA, we hope this has been helpful in identifying at least some of the key areas that you might want to take a look at. So, Jim.
Yeah, thanks, Luke. And I just want to, there have been several questions we haven't been able to get to. One theme that's come through several questions, though, relates to how broad is the effective scope of CPRA. And one thing I would note is in the definition of consumer, it references it has to be a natural person that's a California resident. And so I think several of these questions that go to calculating thresholds, or does it apply to somebody with employees in California? Look at that, the way consumer is defined, because I think that's going to be important to hash those issues out. So with that, thank you for participating today. We appreciate you coming. If you liked it, please complete the survey at the end of it and let us know. This is our last webinar for 2022. We'll have several more of these in 2023. Certainly feel free to let us know if there are things that are on your mind and you particularly want to hear about. Thank you again, and we'll see you in the next year. Thank you.
Thank you.